On behalf of the American Society of International Asia Pacific Interest Group, to all the excellent speakers today, and then to the wider audience at different time zones, and then good evening from Hong Kong. I know good morning from US. Just by way of background, the American Society of International Asia Pacific Interest Group is a group of about 200 people. We have 200 academics, lawyers, arbitrators, think tank specialists, policy experts, who specialize in international law issues in their work, but with a focus on the Asia Pacific region. We're very fortunate to have the ASO headquarters support for to launch this Asia Pacific Interest Group webinar series. We have already kicked off our first webinar on July the 16th. We have a lot of interesting discussion on the international law in the Asia Pacific during the COVID-19 pandemic. And today we are going to have our second webinar, which is focused on the national security issues. Well, the webinar series is intended to bring along the leading experts in the international law fields and to explore topical issues in both the private and public international law and more beyond that is affecting the region. Now, let me also introduce Man Jiao, who is the moderator today. We're very fortunate to have Man Jiao, professor at the University of International Business and Economics, based in Beijing, who is now event manager for the interest group, as well as the moderator for the panel today. So Man Jiao, together with Professor Matthew Airy, unfortunately, he is very busy and he is tied up by childcare duties tonight, from the Oxford University, and myself from Hong Kong U, who are co-chairs of the Asia Pacific Interest Group. We have organized this webinar series to benefit not only the Asia Pacific Interest Group members, but also the international law community at large. I know the time is very limited today, so without further ado, I would like to hand over to Man Jiao. So over to you, Man Jiao. Thank you.
Thank you, Wisha. Good evening and good morning to the audience as well. My name is Man Jiao Chi. I'm a professor of UIBE in Beijing. Today, as Wisha has already mentioned, we are having a webinar on national security in international law from an Asian Pacific perspective. We are very fortunate to have 4 distinguished speakers to join us tonight. It's my time tonight. We have Professor Diana Deseto from COF, School of Global Affairs, University of Notre Dame of the United States, Professor Yuka Fukunaga from Law School of Waseda University of Japan, Professor Prabhash Ranja from Law School South Asian University of India, and Professor Simon Yan from Faculty of Law of University of Hong Kong. So each of them will talk for about 10 minutes on a national security related issue. And then we will engage in discussions among the speakers. And then in the same time, I encourage our audience to put down your questions in the column, the Q&A column. So after the discussion, I will read these questions and point them to the speakers. So without further ado, let me first of all invite Professor Diana Deseto to start the presentation. So Diana, I hand it over to you.
Thank you very much, Man Jiao, and thank you very much, Weisha, and my thanks as well to the American Society of International Law for the opportunity to discuss this extremely topical issue. My task today is to talk in general terms about national security as it relates to general international law. I have 3 points to make in this presentation, which is intended to deliver the same message. Essentially, it is this. The scope and use of national security as invoked by states in modern international law, the international law that is defined under the Charter of the United Nations, has already rejected complete deference to a state's assertion of the self-judged nature of national security. While there may be broad understandings of what national security is, when a state invokes it, it is not under modern international law, and in contrast to classical international law, it is not an assertion that is insulated from either objective judicial or arbitral review, or is also not incapable of being adjudicated upon by tribunals such as the International Court of Justice. Let me elucidate on the first point. There is no longer in modern international law a complete deference to a state's assertion of the self-judged nature of national security. We recall that in Article 1 of the purposes of the UN Charter, this includes the maintenance of international peace and security, which is read alongside Article 39 and other provisions of the Charter, referring to the exclusive competence of the Security Council to determine breaches of the peace and threats to international peace and security. We are also aware that in Article 2, paragraph 7 of the purposes of the Charter of the United Nations, there is what we know to be the principle of non-intervention. And in fact, the International Court of Justice, in the famous case of Nicaragua in 1986, declared what a prohibited intervention is into matters which are essentially within a state's domestic jurisdiction. Let me quote from paragraph 205 of that decision. The court said in that decision that a prohibited intervention must accordingly bear on matters in which each state is permitted by principle of state sovereignty to decide freely. One of these is the choice of a political, economic, social, and cultural system, and the formulation of a foreign policy. Intervention, therefore, is wrongful when it uses methods of coercion in regard to such choices by states, which must remain free choices. This leads me to my second point. The key phrase here in determining national security and when a state asserts national security is also to ascertain what is permitted to a state to decide freely for itself. One cannot, therefore, claim a broad or unfettered space of what, in the parlance of Article 2, paragraph 7, are matters which are essentially within the domestic jurisdiction of the state, if, as I submit, the same state has also already made binding international legal commitments with respect to the subject matter for which the state will subsequently, or at times gratuitously, invoke national security. How does this play out? Let me give you 4 examples. In human rights treaties, for example, states can invoke national security and public order, but these are subject to specific legal criteria. This is why we have the derogations clause in Article 4 of the ICCPR and the general limitations clause of Article 4 of the International Covenant on Economic, Social, and Cultural Rights. In another regime, in international investment law, there are clauses on security exceptions which have interpretive consequences on state responsibility and liability for reparations to investors in the event of triggering such responsibility. These security exceptions have been treated in arbitral jurisprudence as justiciable precisely because generally states have not insulated these treaty clauses from arbitral review through investor-state dispute settlement. Third, in World Trade Organization law, which I'm sure my distinguished colleagues will elaborate on, let me just briefly mention 2 decisions. Cases such as Russia traffic in transit and the recent Saudi Arabia protection of intellectual property rights case, which dealt with a similarly worded security exceptions clause under Article 73 of the TRIPS agreement in relation to Article 14 bis of the General Agreement on Trade and Services, and which is comparable to Article 21, the security exceptions clause in the General Agreement on Tariffs and Trade, demonstrate that the security exceptions clause is now deemed to be justiciable and, in the words of the Russia traffic in transit panel, capable of objective determination in dispute settlement panels at the World Trade Organization. And my 4th example is in international environmental treaties, where compliance procedures and environmental information access rights are themselves also conditioned on qualifications that recognize that states may change or alter the nature of such environmental information access when public emergency or national defense or public security are invoked by states. this functions as either an exception or a qualification. And we see that in Article 4.4b of the 1998 Aarhus Convention, as well as in Article 5.6b of the 2018 Escazú Convention. With those examples, this does lead me to my third point, and I've discussed this at length in the book that I already wrote back in 2012, Necessity and National Emergency Clauses, Sovereignty in Modern Treaty Interpretation. I have submitted and I've argued that the codification of national security clauses in modern international treaties is a significant, deliberate departure from the unreviewable self-judged national security clauses prior to the UN Charter era. The codification into treaties and other sources of international law, including possibly constitutions, domestic constitutions that contain national security clauses. These constitutions can also serve as artifacts of municipal or domestic law that could inform an understanding of a general principle of law under Article 38C of the ICJ statute. This has not been passed upon, but it would be interesting to see from our distinguished panel today whether this is a possibility. These codifications, whether into treaties or other sources of law, tempers the broad and unfettered use of national security as either complete exculpation or justification for a state's otherwise internationally wrongful act. This does lead me to conclude on Article 25, the necessity clause under the Articles of State Responsibility. And this is a classic, or rather a crystal example of the tempering of the usage of national security. This provision, which was recognized by the International Court of Justice in the Gabčíkovo-Nagymaros case as having customary law dimensions, is the best example of how, through codification, criteria, objective legal criteria and subjective legal criteria being incorporated into the assessment of the norm of national security, how we can and we have in the modern international legal system deliberately tamed what used to be a blanket justification of states prior to the UN Charter era. Of course, for states who have frequently invoked national security, the very notion of an international system that would weigh in on the notion of the assertion of national security might seem counterintuitive to the understanding of the principle of non-intervention. But as I have said in points 1 and 2, the non-intervention principle is not in itself sacrosanct. It is also not immutable to interpretation. Where the International Court of Justice has recognized the space of matters that are essentially within the domestic jurisdiction of a state, where there is overlap between that domestic jurisdiction and a state's chosen international commitments, we have seen in the practice of the United Nations and the practice of states under modern international law that that space is increasingly being mediated in other forms of international cooperation. This is why national security, as I submit in conclusion, at least under modern general international law, is not insulated from judicial or arbitral review. It is also constantly being modified by the practice of states towards leaning more towards justiciability. And it's also been codified across a range of regimes that have seen national security play a crucial role as a calibration mechanism to inject flexibility into the notion of international obligations without creating complete insulation. Thank you very much, and I look forward to continuing the discussion.
Thank you, Diane. This is very great summary and insight of national security from a general public international law perspective. You also touched upon some disciplines or branches of international law, and I believe that Prabhash and Yuka will also have opportunities to develop along that lines. But before that, we have the opportunity to hear about the regional perspective of national security. We have Professor Simon Yan from the University of Hong Kong. And I believe, as we all know, in the past few months, the national security issue in Hong Kong and in the region is not unique to Hong Kong, but is getting very intense there. It has been a heated discussion. So let's hear what Simon would say on that. So Simon, please.
Thank you very much, Manjel. And also thank you, Weixia, for the invitation to be here today. So I want to talk about the new Hong Kong law, which essentially was imposed on Hong Kong by the central government, the mainland government, back in June 30th of this year. But I want to begin by situating it in the broader context of the region. And I'm going to outline in a very sort of broad brush way, and I'm overgeneralize statistics of national security laws in the Asia region. And I'm going to go through it quite quickly. I've identified about 8 characteristics. The first is that when one looks at across Asia, national security can be seen in terms of both the old colonial offenses against the state, for example, treason and sedition and other crimes, but also we see the new national security offenses in the form of anti-terrorism offenses. And of course, this was stepped up after September 11th and influenced by developments in the United States, plus by the United Nations. That's the first characteristic. Secondly, we see very wide definitions of national security risks, covering not only external risks, but internal risks as well, different forms involving religion, involving possibly the environment, health hazards, etc. Thirdly is the invocation of very wide powers to deal with these sort of broad security risks. Fourthly is the emphasis on preventive detention measures. So trying to stop things before they occur, and sometimes occurring at a very, very early stage. So very, one might say, exaggerated assessments of risk. Number 5 is the emphasis on speech crimes and expression crimes. Again, along the same lines of trying to stop the potential for things escalating. So when one expresses it in words, that is already a danger. Number 6 is the use of special criminal justice measures. So including special courts, special prosecutors, investigators, closed proceedings. So these are all sort of derogations from the norm, even closed evidence. Number 7 are restrictions on fundamental rights. So many of these jurisdictions will have in their constitution protections of these rights, but these restrictions, these laws are seen as justified restrictions, both necessary and proportionate. That's how they would justify it. And lastly, number 8 are that when we see these jurisdictions imposing new laws, they tend to enhance the capacity of the state to control or to prevent risks, sometimes using anti-money laundering laws, cybercrime laws to deal with internet activity, and also the increasing use of surveillance by technological means. So these are some general, very broad brush characteristics we see across the region. And the first point I want to make is that when we look at this new Hong Kong law, the national security law, one sees many of these characteristics in this law. Now, I don't have time to detail how each and every one of those characteristics is reflected in this law. But in fact, what I would like to spend my time looking at is actually what makes this law somewhat distinct vis-a-vis the Chinese national security law that applies on the mainland, but then also vis-a-vis other Asian jurisdictions. And so I want to just emphasize what is very special and unique about what is going on with this national security law. So the first point to be made here is that this was a law that the mainland created for Hong Kong, because of course the mainland already had its criminal law, which would have offenses on national security. And of course, Macau has its own laws on national security enacted in 2009. But this was a national law made for Hong Kong. And when one steps back to think about that, it's actually, rather unusual, isn't it? That to think that there is a kind of a hole in the territory of a state that did not have any national security law. Well, that's not entirely right. Hong Kong still had its colonial laws from the British, but many of these laws, of course, were drafted in vague and very broad terms. The Hong Kong administration had never invoked any of these laws since 1997, notwithstanding the unrest that we saw in 2019. So, although they may have been on paper, they really weren't effective. This was a situation that sort of called for a response by the central government. And there were different ways they could have responded. One was, of course, to apply wholesale all the mainland laws, but they didn't do that. We had a situation in Hong Kong where we didn't even have an offense of terrorism. It wasn't a crime to commit terrorism in Hong Kong. So that's how out of date, one might say. And in many ways, this new law is sort of playing catch up to the other Asian jurisdictions. So the second main point is that in bringing about this implementation, although in the media you've heard probably a lot of criticism of how tough this law is on Hong Kong, but I think it's important to situate it in the context of the sort of one country, two system formulation of the relationship between the mainland and Hong Kong. I would characterize what has happened here as an implementation that to some extent does respect the autonomy of Hong Kong. But those who are familiar with the one country, two system formulation is one whereby Hong Kong is supposed to have a high degree of autonomy. And that's probably best reflected in Article 23 of our law, which said that Hong Kong on its own was going to enact national security laws. But of course, we tried to do that in 2003, but we failed. And it was just never feasible to bring a piece of legislation through our fractured legislature to do that. It was not a way of approaching this by allowing Hong Kong to do it on its own, which is what I would say happened in Macau. So Macau was allowed to enact its own law because their basic law, their constitutional instrument is very similar to ours. They were allowed to do so in 2009, and there was no sort of national law thrust upon them. Very different in Hong Kong. We weren't able to do that. But at the same time, what has happened here is not a wholesale direct imposition of the mainland law. And as I've mentioned already, there was a specially designed law for Hong Kong. So, and I'm going to make a few other points here where I would say there is a demonstration of a respect for autonomy of Hong Kong, respecting its different system, right? It doesn't practice the socialist system, but at the same time there's a tension here. But I want to just sort of highlight 6 examples of how we see this implementation that is, of course, directed by the mainland, but at the same time, it is an implementation that respects the autonomy in the sense that it's going to allow Hong Kong individuals, people, personnel, government, to apply this law and according to the law of Hong Kong and the customs and practices of Hong Kong, right? But inevitably there is a bit of a tension here. Let's start by looking at the offenses. This is a law that creates 4 new offenses relating to secession, subversion, terrorism, and collusion collusion with foreign governments or external elements. Now, these laws, most of them are found in the mainland criminal law. The collusion one, I think, was somewhat special. It's actually reflects something that Diane spoke about, the principle of non-intervention. In fact, it's a good illustration of how we're using domestic criminal law to try to protect that international law principle. Because one of the ways of committing this offense is to invite foreign governments to intervene in Hong Kong, in the sort of the political sphere of Hong Kong. That was something, of course, that had been happening. There were politicians and others who were inviting other jurisdictions, particularly the US, to impose sanctions. Of course, as you all know, those sanctions have been imposed. These four offenses were specially written for Hong Kong, so we're not a cut and paste. And in doing so, what one finds is a lot more specificity and clarity. Of course, it's not perfect at all, and it can still be criticized for being vaguely drafted. But when you compare it to the law in the mainland, it's quite a major improvement and much narrower. So that, in itself reflects sort of a Hong Kong sort of tradition to have greater certainty in the law. The way they were defined, the examples that are actually given in how you can commit the terrorism or subversion offenses, they actually reflect some of the activities and unrest that we'd seen starting in 2019. So there was an incident where the legislature was stormed by protesters and destroyed, and one sees that type of activity actually reflected in the definition of the offense. Secondly is the insertion of the human rights clause and the rule of law clause in Articles 4 and 5. So again, an attempt to try to demonstrate, at least in writing and in the law, that we're going to respect Hong Kong's human rights regime and its practices of rule of law. And in fact, it expressly mentions the two international covenants, the two human rights covenants. Article 4 actually mentions the ICCPR and the socioeconomic cultural rights covenant and says that they should be respected. Number 3 is that it will be for Hong Kong courts to adjudicate on these cases. And just as Diane was saying, the trend of making national security justiciable is reflected in this law. There will be some cases where there will be certificate evidence, and certificate evidence will not be revealable, but all other things will. Now, it's not exactly the same as any case running through the Hong Kong criminal courts. There will be some exceptional circumstances reflecting the special issue we're dealing with. So there may be closed hearings. Only certain types of judges who've been designated and on a panel can hear these cases. There may be non-jury trials. So when it goes to the high court, the trial by jury may be removed. And the power of interpretation, final interpretation, lies with the standing committee. That, of course, represents quite a radical change in our legal system. We're hoping, of course, that this would only, again, respecting the autonomy of Hong Kong, it will be very exceptional circumstances when they will step in and interpret the law. Number 4 is that we didn't see any preventive detention measures included in this law, right? So unlike in Singapore and Malaysia, where on paper they have the Internal Security Acts, which allow for long periods of detention before trial, and also on the mainland itself, that was not incorporated. The only provision there is that it's a little bit harder to get bail. But already we have one court judgment that has looked at this law, and the 2 judges who were sitting looking at the law said that this doesn't really represent a major change from our existing law on bail in most cases. Fifth point I want to make is that yes, there were some very extensive police powers that were given to a special unit of the Hong Kong police. And then about 2 or 3 days after this law was enacted, we had a very, very detailed 100-page set of implementation rules setting out these police powers. Those implementation rules, it's clear when you look at it, were drafted in Hong Kong by the Hong Kong government, Hong Kong lawyers, government lawyers, and they reflect existing provisions that we have in our law. However, they do, of course, go beyond our existing law. So, there are worrisome powers there, including the power of surveillance without getting a court order. It's been extended in this context. So on the one hand, we're trying to apply the existing formulations of police powers, but at the same time, it is going beyond what we have now in order to address what is thought to be needed for dealing with national security. Now, finally, is Hong Kong's jurisdiction over the crimes. Generally speaking, Hong Kong will have jurisdiction for crimes that take place. There is, of course, extraterritorial jurisdiction, but it will be Hong Kong courts and police that are applying this law. But there is one exception, and again, reflecting this idea that it is a mainland law, and the mainland, when in these exceptional cases apply, they will actually exert jurisdiction in Hong Kong. But probably what will happen is the person will be taken immediately into the mainland to face trial. Of course, the whole idea is extremely scary, and of course, it's a source of great criticism. But we're hoping, of course, that this will not be applied too often. It has to have the approval of the Central People's Government before the mainland office and their officers can actually assume jurisdiction. There is a criteria that is provided in Article 55. On its face, it's meant to deal with very exceptional cases when the Hong Kong government cannot act. It's unable to act because it's either too complicated, too difficult, or there's an imminent threat to national security. Right. So it reflects that balance where it's not high degree of autonomy, but some autonomy. But at the end of the day, the central government maintains its jurisdiction and sovereignty, if you like, over matters of national security in Hong Kong. I'll stop there. Thank you very much.
Thank you, Simon, for the insightful discussions of the characteristics of national security in the Asian Pacific region, and also with a focus on the Hong Kong national security law. And you raised some interesting but very important questions. I already see questions coming in, but I guess we'll have time to deal with the questions a bit later. So now I would like to invite our third speaker, Professor Yuka Fukunaga, to focus on national security from a trade law perspective. I think Diana also already mentioned in a few cases, WTO cases, states, WTO members try to invoke national security to justify its otherwise incompliant trade rules. So we'll see what Yuka would have to say. So I handed it over to you, Yuka.
Thank you, Manjao, and thank you, Manjao and Weisha, for organizing this very interesting webinar and giving me an opportunity to talk with other colleagues in this very difficult time. Well, in my very short presentation, I will try to address two key questions. The first question is related to WTO dispute settlement, and the question is, how should the WTO panel review disputes involving national security clause, especially Article 21B of the GATT. Diana already mentioned. I'll try to explore on that issue. And this question is a very difficult one and involving a number of burning issues. And there are now two cases going on at the WTO panel. One is the US measures on steel and aluminum products, and the other is Japan's export control measures. And the panels on these cases have to find the right answer to this very difficult question. But thank God I'm not the panelist and I don't have to answer this question. And I'm not trying to answer this question in this short presentation. And what I'm trying to do today is just to place on the table the issues that the panel would have to answer when dealing with this issue. And the second key question that I want to address, if I have time, is how should WTO members deal with these trade disputes involving national security? In other words, is the WTO dispute settlement system the right forum to deal with these disputes? And Diane said that these disputes are justiciable, but I may try to give a different perspective. Well, these disputes may be reviewed in a judicial way, but should they be reviewed in a judicial way? Perhaps there may be other ways, other non-judicial ways to handle these very politically sensitive disputes. Now, let me start with the first question, which is how a WTO panel should review GATT Article 21B. And as I said, there are several issues, but I'll focus on two issues. The first issue is whether a panel has jurisdiction to review Article 21B. And as you know, Article 21B justifies an action that the member considers necessary to protect its national security interests, rather than an action that is necessary to protect national security interests. So some members, like the United States, argue that this provision is self-judging and panels cannot make a review on this. But as Diane said briefly, a panel in Roster Transit gave an answer, although I don't know if that answer was the right answer, but anyway, it gave an answer. And according to that, the panel said, the phrase considers necessary qualifies only the chapeau of Article 21B and not the subparagraphs. And one of the subparagraphs require an existence of an emergency in international relations. And according to this panel, whether an emergency in international relations existed or not is amenable to objective determination by panels. That means panels have jurisdiction to determine whether there is an emergency in international relations or not. Well, that finding makes me wonder, does that mean the subparagraphs are amenable to objective determination, but the chapeau is not? But anyway, this panel also said that the refusing to exercise jurisdiction over Article 21B would be contradictory to the panel's obligation under the DFU to make findings and members' right under the DFU to seek redress of WTO violations. So perhaps that means that, according to this panel, panels have jurisdiction to review issues under Article 21B. But I think the more difficult issue is how differential the panel review should be. And the fact that the panel has jurisdiction does not necessarily mean that the panel can make an extensive review. And this is about the standard of review. And we know that the appropriate standard of review always lies somewhere between total difference and de novo review. So where does the appropriate standard of review for Article 21B stand? Again, the panel in Roster Transit case gave some answer to this issue as well. And this panel applied 3 different standards of review, ranging from total difference to de novo review. First, with regard to subparagraph 3, which is about the existence of an emergency in international relations, the panel said well, the panel can make an objective assessment, objective determination of whether there existed an emergency in international relations or not. So by saying this panel gave no or little difference to members' determination, members' assessment as to circumstances, assessment as to whether there was an emergency or not. And on the second issue, as to the scope or the meaning of essential security interests in the chapeau, the panel said, it is generally left to each member's discretion to define what it considers to be its security interest. But so by that way, the panel gave a significant difference to members, but at the same time, the panel said the discretion is not unlimited, and it's limited by the good faith principle. And more specifically, this panel said that the essential security interest must be expressly articulated, and the measures at issue must not be implausible as measures to protect the national security interest. So it gave a significant difference, but it makes some examination regarding the scope or the meaning of the essential security interest. And on the last issue, as to the necessity consideration in the chapeau, the panel said that it is for each member to decide whether what is necessary to protect its national security interest. So effectively, this panel considered that the necessity consideration in the chapeau is of self-judging nature, although it did not say so explicitly, but effectively it gave total difference to invoking members, in this case, Russia. So I think these findings are, generally speaking, very carefully balanced, but not without question. And let me raise two questions. First, as to the standard of review regarding subparagraph 3, to me, the panel said the existence of an emergency is amenable to objective determination. But to me, whether certain circumstances amount to an emergency in international relations necessarily involves subjective assessment of circumstances. So perhaps that means some deference should have been accorded to the assessment of the circumstances. And the second question that I want to raise is about the chapeau. Well, as I said, the panel said that the good faith principle applies to the meaning of the or the determination of the security interest, but the panel gave total deference to the necessity of the measures. But I don't fully understand why the good faith principle applies to the meaning of the security interest, but not to the necessity. If the panel, if the member has to define its essential security interest in good faith, perhaps it should also consider the necessity of the measures in good faith as well. So this is my question towards the panel findings in Russia Transit case. Because I'm running out of time, let me go straight to the second question. Just briefly, should the panel, should the parties, should the members bring those national security disputes to WTO dispute settlement? Is WTO dispute settlement suitable to handle these disputes? Personally, I'm very skeptical about this. Well, if the complainant wins the case, it could say, well, we are right. For example, the United States should not have imposed tariffs, or perhaps Korea could say against Japan that, well, Japan was not justified in toughening export controls and so on. So a win for the complainant could give them another reason to blame the invoking members. But I'm very skeptical that the US, for example, if it loses, would not, I don't think the US would revoke the tariffs on steel and aluminum, even if it loses the case. And for Japan, I hope that Japan will comply with DSB decision if it loses the case. But I'm pretty sure that distrust of WTO will grow in Japan if Japan loses in this case. So what I'm trying to say is that trying to settle these politically sensitive disputes in the WTO could simply undermine the credibility of the WTO system, and that could give a final blow to the already waiting global trading system. So thank you very much for your attention, and I hope we have a discussion on this matter further. Thank you.
Thank you very much, Yuka, for your intervention. I think it's very helpful analysis of Article 21 National Security Exception of the GATT. And also, I sense you, this is my sense, you raised the question that the national security exception could be politicized to some extent or in a sense by countries. Although we only have a very limited number of cases in the WTO, I think it is worth noting in the future whether we have more such cases, especially considering that the global trading system is now in a great transformation nowadays. So talking about the transformation, I believe everybody in the field of international economic law and international law in more general term would have noticed the transformation of global investment governance. There were a number of developments in this regard. And for example, the EU has tightened its screening scheme over foreign investments, many of these investments coming from China. And there are, of course, already quite a few cases citing national security between US investors and Argentina during the financial crisis. We have Professor Prabhash Ranjan, a leading expert in this field. He has written a lot in this regard, and now we will be very happy to see what Prabhash would have to say on these very cutting-edge issue. So Prabhash, please.
Thank you very much. Good evening from New Delhi, India. I'm really delighted to be part of this panel. My mandate is to talk about national security in context of international investment law. As we see economic backlash against economic globalization, we are witnessing that a large number of countries are invoking national security as a reason to deal with foreign investors differently. And therefore, when we talk about national security in context of investment law, often countries try to rely on the national security exceptions which are present in bilateral investment treaties, which are the most important source of international investment law. So in the limited time that I have, I wish to make 4 points for your kind consideration. The first point pertains to the architecture or the structure of the essential security interest clauses that we find in investment treaties. Broadly speaking, these essential security interest clauses can be divided into 2 categories. The first category belongs to what can be called as the first generation or the old generation investment treaties. Now, if we look at these investment treaties, we will find that the essential security interest clause is often clubbed along with other permissible objectives. So for example, if we take Article 11 of the US-Argentina BIT, the BIT under which a number of disputes arose, and then Argentina relied upon Article 11 of the US-Argentina BIT to justify its economic emergency measures. In Article 11 of US-Argentina BIT, essential security interest is clubbed along with public order. Likewise, another example that I can offer to you is Article 11.3 of the India-Mauritius BIT. This BIT came into picture when Devas brought a case against India known as the Devas versus India case, where India again relied upon this particular provision to justify its regulatory measure. Now, this particular provision combines essential security interest along with protection of public health. So the point that I'm trying to make is that in the first generation or the old generation investment treaties, you have the security interest clause being clubbed along with other permissible objectives. And when we compare this or contrast this with the new generation or the second generation of investment treaties, we find that there is a clear difference. The new generation of investment treaties are more inspired from the GATT Article 20 and 21 architecture. So we find that there is a separate provision which talks about general exception clauses, and there's a separate provision which talks about security exception clauses. The other important difference to note is that in the first generation BITs, the language of which it considers necessary is missing. And as a result, the tribunals have held that these clauses are justiciable. Whereas in the new generation investment treaties, we find the self-judging language being present. And it would be interesting to see how an investment arbitral tribunal will interpret the self-judging language. In my opinion, it might interpret it in the same manner as the WTO panels have done for Article 21 of GATT. This brings me to the second point that I want to talk about, and this is about the breadth of the essential security interest. One of the important issues right from all the Argentina cases involving the two Indian cases has been that what is the meaning of security interest in context of investment law? Is it restricted to only purely military or security related threats? Or does it also cover other kinds of emergencies such as economic emergencies or health emergencies? If you look at all the Argentine tribunals, all the tribunals have held that the gamut of essential security interest is not restricted only to purely security related interests. They also extend to economic emergencies. Now, the point where the tribunals differ with each other is how severe the economic emergency should be for a state to justify its action under the essential security interest clause. Now, here, if we look at the threshold which the CMS versus Argentina tribunal laid down, that threshold can be called as the threshold of total collapse, which is a very high and an impossible threshold for any host state to meet, because according to this threshold, unless or until there is a total collapse, it will be difficult to say that the economic emergency has attained the status of an essential security interest. On the other hand, you have cases such as Continental Casualty versus Argentina, and likewise the two cases involving India, Devas versus India and Deutsche Telekom versus India, where the tribunals have differed from the CMS approach and have held that the threshold cannot be as high as total collapse. So the threshold has to be high. It has to be an essential security interest and not any security interest. However, the important point is that if we define the threshold to be as high as what the CMS tribunal did, then it would be practically impossible for a large number of countries to make use of the essential security interest provision. This brings me to the third point, which I want to talk about. Previous speakers have also talked about this, and this is the nexus requirement, or the most common nexus requirement that we find in investment treaties on essential security interest clauses is necessary. Now, again, we find disagreement or sort of divergence of approaches between the arbitral tribunals on this question. Some of the Argentine arbitral tribunals have tried to interpret the word necessary by using Article 25 of the ILC Articles on State Responsibility, which, as Diana mentioned, that it's a very high threshold, which will be very difficult or almost impossible for a country to justify. Whereas some other arbitral tribunals, most importantly Continental Casualty and Deutsche Telekom versus India, the more recent one, has said that the meaning of necessary in investment treaties cannot be interpreted by looking at the customary international law defense of necessity, because the treaty defense is different from the customary international law defense of necessity. Now, in this regard, I find the test which the Deutsche Telekom Tribunal has laid down to be very, very useful, and it would be useful for us to discuss this and for future tribunals to develop this further. It's primarily a two-pronged test, and the tribunal said that for a measure to be necessary, it has to be A, principally targeted at achieving the essential security interest, and B, it should be a measure which must be objectively required to achieve the essential security interest, taking into account the reasonable alternatives which are less in conflict or more compliant with international legal obligations. Now, this obviously, as we know, is inspired from the WTO jurisprudence of the less alternative restrictive test. Even the Continental Casualty Tribunal talked about this. There are legitimate criticisms of this. For example, what is the doctrinal basis for the tribunals to talk about the less restrictive alternative measure test? However, in my opinion, this approach to interpret necessary is far better in terms of giving adequate deference to the countries concerned than using the customary international law defense of necessity. And this brings me to the final point, which I want to talk about, which other speakers have also talked about, and this is on standard of review, which obviously is a very, very important matter whenever we are talking about security interests in any branch of international law, not just investment law. Now, as we all appreciate that the tribunal has to do a very difficult balancing act when it talks of standard of review. On the one hand, it has to be sensitive to the security concerns of the country, because countries are generally extremely sensitive when it comes to security matters. So the tribunal has to be sensitive to the country's security concerns on the one hand. And on the other hand, it also has to ensure that countries do not abuse their essential security interest provision just to wriggle out of their investment law obligations or international law obligations. Now, this is a genuine concern, given how we see many countries, especially in context of trade, as we have seen, countries are invoking the essential security interest clause to do nothing but to actually adopt protectionist measures. So tribunals have to play this very delicate balancing act very carefully. And again, one can divide the investment law jurisprudence into two parts. On the one hand, we have the CMS, Enron, and Sempra tribunals, which accorded very little deference to Argentina when it came to examining the standard of review. And the reason for that was that they used the customary international law defense of necessity to interpret necessary, and therefore there was very little deference accorded to Argentina. On the other hand, if we look at the approach of the Continental Casualty and the Devas versus India and Deutsche Telekom versus India, we find that these tribunals gave a wide measure of deference to the host state in not just defining what is essential security interest, but also in examining whether the measure adopted is necessary to achieve the essential security interest or not. So again, in my opinion, the approach which the two Indian tribunals and Continental Casualty Tribunal has adopted would be the right approach when it comes to looking at standard of review. So I hope I have a minute left. I'll conclude by saying that this is indeed a very important topic. And as we move towards a world where more and more countries are turning inward, or more and more countries are turning protectionist, it is quite possible that we might see more and more countries invoking the national security defense. And therefore, it is important, and especially for investment treaty arbitration tribunals, to develop a coherent jurisprudence on this so that it acts as a clear benchmark both for the foreign investors and the host state who wish to rely on the national security exception. I'll be happy to take questions with this. Thank you very much.
Thank you very much, Prabhash. Very, very insightful review of international investment arbitration and investment treaties with regard to national security. I think your closing sentence about more and more higher possibility of states invoking national security exceptions in the future, I think is quite alarming to the international community, which actually brings me to a common question that I have to each of our distinguished speakers today. But before I raise this question, I would like to invite our audience. After the 4 presentations, I would like to ask and invite questions from our audience. Please type down your questions and then I will collect them and then ask the presenters, the speakers, to answer the questions. So while we are waiting for more questions to come, I do have a question, which is a common one. So from what I've heard from the presentations, we see that national security actually exists in international law, in human rights law, trade law, investment law, and treaties. It's like almost everywhere in different branches of international law. And at national or regional level, as Simon said, many countries have enacted national security laws, although these laws are different to different extents. And then further, Yuka and Prabhash has highlighted the cases. It shows clearly that national security provisions in some of the treaties have been applied and reviewed by international adjudicators, WTO, dispute settlement body, and different investment arbitration tribunals. Well, obviously, national security, at least from my observation, is not unique to a specific country or region or to a specific branch of international law, a specific treaty. So the question is, to each of you, whether and to what extent do you think a common norm of national security could be achieved by the international community, could be and should be achieved? So I give this question to each of you, and I would like to hear your insights on this. So feel free to intervene. Actually, ASO expect the panel of speakers to engage in more active interactions. So I would like to invite each of you to make a response.
If I may,
Sure.
Andrea.
Sure, Diana, please.
I very much appreciate and thank you to my colleagues for your illuminating presentations. What I think is so palpably demonstrated by each of the interventions is that there is an active dialectic, interpretive dialectic taking place, not just on the content of national security when invoked, but also the legal consequences of national security when invoked. So I do think we take a broad reading of 31.3c of the Vienna Convention on the Law of Treaties, that there could be relevant rules of international law that will be drawn from by various tribunals, given the diversity of practices on the interpretation of national security and its consequences. That said, I say this with a grain of salt because, as we know, not all tribunals and not all treaty regimes function in the same way. There are limits to the kind of grafting and the kind of transposition of ideas and content with respect to the scope of national security. I actually think, much as Yuka has discussed it earlier, it will not be, there will be space for deference for how a state defines its national security. Where I think there will be a gap or a gulf of difference is how tribunals will treat, and unfortunately that happens in the era of Zoom, how tribunals will treat the legal consequences of the invocation of national security. Trade law might have a different approach to this than investment law, than environmental law, than human rights law. And to that extent, I think while we can have a common norm that broadly accepts many possible dimensions of national security, the legal differences on legal consequences will be what might spell the difference here.
Great. So anyone else? Feel free. Simon, please.
Maybe I'll just say a few things. Yeah, I think it's going to be very difficult to come up with a norm that's going to be useful for all context. I mean, I think it may be stated in such generality that it may not actually be helpful when you have to deal with a specific problem. And I also want to say the old and the modern forms of conceptions of national security, which Diane talked about, I think there's that tension still exists. So states, continually want to strive to self-define national security, and yet at the same time, to come up with a norm, it means the imposition of some objective standards. In preparing for this, I noticed some interesting comments from our Hong Kong government in relation to the so-called Johannesburg principles that deal with national security and freedom of expression, which of course, were set out, in a very helpful manner and very detailed manner by very distinguished experts. And then when it was put to the Hong Kong government, basically the Hong Kong government said, well, these are not binding on us. No country has actually adopted these. And so, and they don't really cater to all possible situations. So it's that kind of a response. I think it makes it very difficult to arrive at some consensus on norms.
Great. It seems that we have sort of different perspectives on that, but that's great. So now, shall I invite Yuka or Prabhash? Yes, Yuka, please.
Okay, thank you. Well, thank you very much for your very interesting and very difficult question. And about sort of the common principle of national security under general international law. Well, I think the concept of national security interests is common probably in all areas of international law. It's not like national security interest in trade law is this, and national security interest in investment law is this, and so on. It should be the same in all areas of international law, but the concept itself is very flexible. So I don't know whether it makes any sense to say that there is only single concept of security interest. Anyway, that single concept is very, flexible, changes all the time, and so on. But when it comes to the question of whether to what extent measures should be justified as a national security measure, the answer to that question may be different from in each area of international law, or it is different depending on the treaty language. And as other speakers mentioned, the treaty language regarding national security is different. For example, WTO, GATT Article 21 uses the term consider, but some investment treaties do not use the term consider. And perhaps we have to think about we have to think about the difference of the text. But personally, although we have to interpret treaties in accordance with Article 31 of the Vienna Convention, but I'm not sure to what extent the term consider changes the meaning of, or the meaning of the national security clause. Even if there's no consider in a treaty, still courts should accord certain difference. And even if there is a term consider in a treaty, some examination has to be done. So I understand that we have to respect the text. We have to take into account the difference of treaty languages, but at the same time, the difference of treaty languages may not be so determinative as to whether certain measures are justified as security measures or not. That's all. Thank you.
Thank you, Ika. So Prabhash?
Yeah, I think in answering this question, one thing that we need to keep in mind is the overall political context in the global economy today. There is a nationalism frenzy today, whether we like it or not, in my own country, in the US, in large parts of Europe, etc. And this nationalism frenzy and the rise of populism, it sort of changes the context in which the legal norms will be interpreted. So it is not just an exercise in vacuum. It is not just an exercise of applying or interpreting the legal norms, but one also has to keep into account the overall context in which the tribunals and the courts operate. I would love to believe that the tribunals and the courts are completely immune from the overall political context, but we know that that's not really true, and the political context does play a very important role. So I think this is a factor which one has to keep in mind when we try to answer this question of whether there can be a common norm across different branches of international law when it comes to national security. The second point, as Yuka mentioned and others have mentioned, is given the fragmented nature of the international law system, uh, it's again that's one challenge that one will have to overcome in terms of trying to develop a common approach towards national security. uh, uh, Trade law, at least there is one treaty, and there is even if you don't have the appellate body, you at least have the panel, and therefore there would be interpretation and there might be some degree of consistency in what different panels would say as regards Article 21. But in investment treaty law, that's a major challenge, because not just the adjudication process, but even the substantive law is scattered across in large number of bilateral investment treaties. And unless until you have some kind of multilateral mechanism, either in the form of a multilateral investment court or some other mechanism, it might be difficult to develop a common jurisprudence on this. And as Yuka rightly mentioned, some investment treaties, the new ones talk about which it considers necessary, whereas the older ones do not. And I think which it considers, I completely agree with her, which it considers is not so much about determination of security, but it is more about determination of the measure which has been adopted to achieve the security objective. So how much difference this self-judging language would change? That's again not very clear. It would vary from the approach which the tribunal would adopt. So it's a difficult question to answer, but I think one common point on which we all seem to agree is on the question of deference, that the tribunals or the international courts cannot accord complete deference, but at the same time, it should not be a de novo review when it comes to security measures. And I guess there, striking a fine balance is something which all tribunals, and that could be the common approach which all tribunals and courts could adopt. Thank you.
Thank you very much, Prabhash, and thank you to all the speakers. As you have correctly pointed out, yes, it is very difficult to develop a common norm of national security, at least at this point of time. I would completely agree with you. As Simon has mentioned, at least there should be a certain level of consensus, and the consensus achieving is actually influenced by many factors, as Prabhash mentioned already, the political economic situations of the countries and the different kind of factors, and then that would be difficult. So let's wait and see. I mean, in the future, let's wait and see if it is possible, at least in certain area of international law, for example, in international trade law based on WTO law, will it be more possible that a certain common law norm of national security be developed given the situation that the WTO has a compulsory and exclusive jurisdiction over cases citing a WTO covered agreement? So that would be something maybe I believe in the future deserves our attention. So now I think we have two interesting questions coming in. If we have time, we'll go back to the national security discussion, but now I think it's good to reply to these questions. I think the first question, let me very briefly read it out in case the audience wouldn't have access to this question. I think it's directed to Simon. It says, don't you agree that the national security law in Hong Kong is draconian and will be abused to suppress dissent and impinge on fundamental rights of the citizens? As I said, I think it's raised to Simon, but I mean, feel free, other speakers feel free to intervene if you have anything to say. So, but I think, shall I give it to Simon first?
Okay, well, thank you, Kumar, for that question. Let me just begin by making four fairly quick points in reply. I think the first point is that, yes, on the face of this law, there is danger for the nightmare situation to arise. The nightmare situation, of course, is where Hong Kong becomes a police state. You have mainland officers going about enforcing the law, and no one knows what's going on. People are being arrested, taken into the mainland for trial and convicted, and no one knows what happens to them. That is possible under this law because of the doors that have been opened. But I don't think it was the intention of the drafters. I don't think it was the intention of the central government to use the law in this way. That was basically the thrust of my presentation. It was my belief, based on how it's drafted, and even based on statements that had been made by Hong Kong officials, mainland officials, that it was meant to respect the autonomy of Hong Kong, right? Not as much as some people would like, going back to what may have been originally intended in Article 23 of the Basic Law. But I think it's still respect for some degree of autonomy. The second point I want to make is that, as I said earlier, it's still going to be Hong Kong people who are going to be making decisions on prosecution, and the police making the arrest, etc. And also, most importantly, is the courts and the judges and the lawyers, and they're all trained in the common law system. So that gives me some assurances. And based on what we've seen since 2019, whether it's protesters or those against protesters, the activity that we've seen, I think in any, the violence, etc., that would be caught and prosecuted in any jurisdiction. I think it may not be the same label of the offense, but I think under the Hong Kong laws, we would be dealt with pretty well in the same way in any jurisdiction with these national security laws. But number three, where of course there is increasing concern, is where people are being prosecuted for speech crimes, and there's no risk of violence or any other unlawful activity. And we are starting to see that. However, at this point in time, it looks like it is being directed in a very focused way. And it's, of course, the very sensitive issue that China has with territorial integrity. And it's basically calls for Hong Kong independence, self-determination. That is being specifically targeted. I would say, of course, this was not in the past. I don't think our laws in the past allowed us to tackle this. This new security law does. It's, of course, from a human rights and freedom of expression point of view, most undesirable. But if it is only confined to expressions of independence, then one might be able to understand and hopefully keep it confined to that. Of course, we're now starting to see how it extends to things which are not explicitly about calling for independence, but the government is saying, well, it has the same effect. An example of that is the so-called 5 demands. None of them explicitly are about calling for independence, but it was part of other protesters at the time that were making that call. And so government has now said that it mounts the same thing. And we still have, it waits to be seen whether courts will accept that. That leads me to my last point, and where I do have some concerns, is I think we are starting to see police and prosecution overreach. I mean, we had a recent protest where a 12-year-old girl was chased and pushed down. And so it seems to me that this new national security law has sort of emboldened the police and prosecution, and we're starting to see some overreach. What mechanism is there for us to have balance? The courts, of course. So we'll have to wait for cases to go to the courts. And then hopefully, of course, the most senior people in government, but it may be that we have to wait for change in those people. Of course, we don't have democracy, so we can't elect them out. But that's one concern. We don't have great oversight mechanisms for the police in Hong Kong. So that's one area of concern.
So Diana,
Can I add just a little bit?
Sure, please.
If I may, Simon very rightly pointed out earlier that the law as written makes reference to the maintenance of obligations of Hong Kong under the International Covenant on Civil and Political Rights and the Covenant on Economic, Social, Cultural Rights. This is an example of an interface of national security at the domestic level and at the international level that could be used under individual circumstances, specifically because if we look at the derogation clause in the ICCPR, it does require that if there is an emergency measure taken to suppress specific ICCPR rights, it must not only be consistent with international law, restricted to the exigencies of the situation, second, and third, must not be discriminatory in its application. Those are clear legal criteria that could be tested on a case-to-case basis. Same with the Covenant on Economic, Social, Cultural Rights, which is a broader general limitations clause, but which also contains the non-discrimination standard, also contains guarantees with respect to the necessity of the measure and the proportionality of the measure. I think these could be a possible fertile ground for national security at domestic and international levels to converge before Hong Kong courts.
Thank you very much. So we have time for I think the last question. It's from Joya from Bangladesh. And the question is about recent ethnic cleansing in Myanmar. And millions of Rohingya people are staying in Bangladesh as refugees. And there was already a case going on in the International Criminal Court by Gambia against Myanmar. But what can UN Security Council do to make Myanmar more accountable to stop such act and stop broader threat? So the question is not direct to a specific speaker, but I sense it's more like to Diana, but the other three speakers feel free to intervene. Diana, would you please? Yes.
Thank you, Manchal. The case is actually pending before the International Court of Justice. That is a case filed by the Gambia, triggering Article 9 of the Genocide Convention, particularly the obligations of Myanmar to stop, prevent, and punish ethnic cleansing as it occurs within its borders. That's a pending case, and as the principal judicial organ of the United Nations, I can quite imagine the Security Council waiting for the outcome of this case, pending fact-finding on this issue. However, this is not to say that the Security Council cannot, on its own initiative, use its authority under the Charter of the United Nations to make certain determinations as to whether or not there is, and when it has done so in the past, identified the existence of ethnic cleansing, it is tied to its determination of the maintenance of international peace and security. I actually think this is feasible for current members, non-permanent members of the Security Council to raise. There are two members of the Association of Southeast Asian Nations who are currently non-permanent members, Indonesia and Vietnam. So if there were to be any political initiative to try and bring this issue before the agenda of the Security Council, there is an ideal space within which to do it, especially with Indonesia's concern for the treatment of the Rohingya communities. What's unfortunate is that Bangladesh is not participating in the case before the International Court of Justice. So there is a possible gap with respect to fact-finding, but we will still try to see more of what can unfold, given that the case is heavily reliant on the facts that are derived by the independent fact-finding mission designated by the Human Rights Council.
Thank you, Diana. As time goes, I'm afraid I have to stop here. Again, I would like to on behalf of ASIL Interest Group, thank ASIL and our 4 distinguished speakers, and above all, the audience. At the end, I would like to invite our audience to stay tuned. We'll have a number of more these webinars in the future, so please stay tuned and take a look at the ASIL websites for our advertisement. So with that, thank you very much and hope to stay in touch and take care. Bye-bye.